Today, I just feel like we were supposed to talk about the paternity, being that all of Mr. Weems' motions were struck. Kind of that was it was a different setting when we went to mediation. No,
When you say it was a different setting, what do you mean?
the only thing that was presented by the attorney was just custody things. Nothing, we were supposed to go basically with the financials. The financials were still never turned over. Even there was a new order put out to turn over the financials. It's like I paid to go to mediation for nothing because you did not come with the documents. Again, it was 7 times the court ordered these documents.
Okay, now you're getting into substance. I just wanted to make sure we're in agreement as to what we're working through, which it sounds like is paternity, and then the consequences thereof. If Mr. Weems is Natalie Chance Jr.'s father, then that generates certain obligations on his part, which would be child support. I know there's been a lot of back and forth about insurance coverage. I think that's been sorted out, but I don't need you to say yes or no quite yet because you'll get a chance to cover that. But it sounds like you agree that what we're working through today is the question of paternity and the consequences, the financial and legal obligations that flow from that. Do you agree with that?
I agree with that.
Okay. Mr. Patillo, your thoughts about what we're doing today?
Yeah, thank you so much, Your Honor. The question of paternity was resolved in February. Mr. Weems took a paternity test, turned the information over to the court and to Ms. Chance. Thereafter, we filed a counterclaim on the question of custody because Mr. Weems had serious concerns about the care and custody of the child, of course, in the current custodial parent's care, and would like the court to address the issue of custody of the child. We've turned over our financial affidavits. We've turned over W-2s to the court. We've turned over the child support worksheet. We've turned over our consent parenting plan. And Mr. Weems simply wants to go forward with the terms of consent to parenting plan.
Okay, couple questions about that, and then I think we can get into substance. You mentioned counterclaim and related things. You agree that Judge K has resolved those?
Yes, Your Honor.
Not necessarily in the way you'd want them resolved, but those aren't properly before me now.
Correct, Your Honor. We'll revive those at a later date.
Okay. And I think he indicated you could do that at a later date. When you say you turn things over to the court, W-2s, et cetera, whatever you are representing that you handed over to the court, copies would have been made available to Ms. Chance as well.
Yes, sir. Ms. Niles has made it very clear to all parties that all parties will be included on all emails and correspondence to the court.
Okay. I'm not doubting that you did. I just wanted the way you described it. I want to make sure there wasn't a mistake on your part that, well, I need to get the exhibits to the court because we say that, and they didn't also flow to Ms. Chance. But you're not relying on anything. You don't intend to rely on anything today that has not already been presented to Ms. Chance.
No, Your Honor.
Okay, and it may have been presented later than you wanted, but we'll see. We'll march through this. I've got the exhibits in a folder here, and when it's Mr. Weems's opportunity to present evidence, we'll work through that, and that would be a chance for you, Ms. Chance, to say, I am seeing this document for the first time in my life. And then Mr. Patillo will be able to show me, if he can, well, actually, here's an email that delivered those documents to Ms. Chance and to Ms. Niles. So we'll take it one step at a time. But I'm going to turn to you then, Ms. Chance, and ask you to present what you want to present. It doesn't sound like we need to relitigate paternity. It sounds like the test was taken. Mr. Weems is Natalie Jr., if I can call her that, Natalie Jr.'s biological parent. And from that flows legal obligations and some legal rights that he may seek to vindicate partially today, but maybe through other proceedings that he would need to bring. So it sounds like we would be focused more on the financial obligations that flow in terms of child support, covering medical expenses, et cetera. So I'm going to ask you to make whatever presentation you want. If you want to testify, in other words, talk about things, not just here's an exhibit, you can see from this exhibit, this is the salary I make, et cetera, then you need to be put under oath because one, testimony needs to come under oath, but two, Mr. Patillo has an opportunity to ask you questions. It's not just you get to tell your side of it, and because you're not on the witness stand, then they don't get to ask questions. And they may have no questions for you, but if there are things you're going to relay to me, not through the admission of records, but through your spoken word, then that needs to be under oath. And when you're done talking about the things you want to discuss, you should know that I'll turn to Mr. Patillo to see if he's got any questions for you about the things you talked about. Does that make sense? You got to answer out loud. Yes. Okay. All right. Then we can proceed however you want to proceed.
I just deliver my documents. First, there's a motion in for contempt.
Say that again.
There's a motion for contempt, and I think.
There are a lot of motions for contempt. And so I need you to be a little more specific about which one or ones.
There's one for child support. The child support was paid, but I put in for a ruling to see why it wasn't paid on time.
So why don't you let me know where you think we are right now with child support? I know at one point none had been paid. Let me take one step back. My understanding is that the obligation on Mr. Weems to pay child support, the court-ordered obligation began, I think it was in June of this year. So not long ago, a month plus some weeks. And it set, I'm get the number a little off, $900 and something a month. And in the month of June, you contend no payment was made. And then for a while in July, no payment had been made because you filed a motion. But it sounds like in the interim, something has been paid?
Yep, the child support has been paid.
Okay, is it current as of today, which is July 22, Mr. Weems has paid 2 months of child support?
Yeah.
And when he paid that, did he hand you a bag of cash or was it a Zelle transfer? How does he get the funds to you?
He Zelled it to me during mediation.
Okay. Is Zelle an acceptable form of payment for you?
It is.
So on a going forward basis, Zelle works.
It does.
Did the judge establish a date by which payment should be made each month?
He did, the first of each month.
First of each month, although I guess for the first month, it wasn't the first because it was a few days in. So in a week and a few days, I guess it's going to be next Saturday is the first, 2 Saturdays from now, Mr. Weems would be expected to Zelle you another whatever the amount is.
Correct.
And that would be consistent with what you understand the court order to be.
Consistent.
Okay. Mr. Patillo, is that your understanding of how the flow should work?
Yes, sir. My understanding, the order says the 3rd of each month, but we can check that in the.
We'll check. And I think fits because I think that's when the order was entered. And so it created the immediate obligation. And I'm not trying to change anything. The order says what it says. And that's where we are now. I'm free to amend the order if the parties agree or I conclude that the 15th makes more sense because of when Mr. Weems gets paid, but we'll talk about that. But there is a date certain each month by which Mr. Weems is to pay that amount to Ms. Chance.
Yes, Your Honor.
Okay.
And the reason it wasn't paid on the 3rd of June was because Mr. Weems was filing through his employer, which is Fulton County, to have it directly taken from his check. And there's a lag time in that taking place. So he simply paid her cash at mediation or through Zelle at mediation while that paperwork was processed through. Once it's processed through, then he'll be directly coming out of his paycheck.
And how does that flow to Ms. Chance? Is it like an ETF? It's a funds transfer? It wouldn't be a Zelle from the county.
No, it would just be a direct transfer from his bank account to her bank account.
Okay, so Mr. Weems had Ms. Chance's bank account information so that he could make that transfer work?
Correct.
Yes, sir. That is correct. What Mr. Patillo said, the order came out on the 17th of June. So it went retroactive back to the 3rd, then the 3rd of each month. So I took care of both of those payments.
Okay, I appreciate you taking care of them. I want to make sure that whatever you're trying to set up with the county for what I'm going to call automatic transfer is going to the right place. You obtained from Ms. Chance routing information? Okay, got it. And when should that be effective?
It's been a delay, and that was the whole reason for the delay, because I have emails which I sent to the payroll.
I'm not concerned because you have made Ms. Chance whole on my watch. You're not behind yet. So what I want to know is what's your best guess as to when the automatic transfer will be working? Because if it's not working as of August 3rd, you're going to Zelle her the money. Because Ms. Chance will let me know if you don't, and I would encourage her to let me know. And you'll keep on the 3rd of each month zelling her the money until the automatic transfer kicks in. I'm wondering what your expectation is.
And that's, sir, yes, sir. And that's what I was trying to explain to you. I sent it to 2 different offices. They sent it to another office. It was a delay. So she mentioned mediation. I said, let me just send it to you. So I don't know when they will, Fulton County will get in line with this.
Okay, I wouldn't hold your breath. As a Fulton County employee, I find that things don't always flow quickly when you're trying to do a direct deposit or withdrawal. Eventually, it will kick in and then it's mechanical. How are you going to know on August 3rd whether you need to Zelle Ms. Chance the money or it's been pulled out?
I will confirm with payroll.
Okay. And if they say it's not ready yet, then by close of business on the 3rd, you would transmit through Zelle that amount to Ms. Chance.
That's right.
And then we'll repeat the process on September 3rd if it's not in place. Okay. Ms. Chance, I want to turn back to you then. It sounds like Mr. Weems is current. Time will tell when we get to August 3rd what happens. But he's told me in front of you that if the automatic transfer is not working, then you'll see another Zelle on the 3rd. And then hopefully, if not by August 3rd, by September 3rd, no one needs to do anything. It's just a matter of course, the county transfers that into an account. Did you provide an account number to Mr. Weems that's an account that works for you?
He asked for no account number. I provided no account number.
Okay. Since we're on the issue, I want to clear things up when we can. What bank do you think the money is being sent to when it's going to be transferred from your pay?
It will be transferred from Chase Bank, and I have previous bank account information. That's how I was able to send the other 2.
But Chase is your bank,
It is.
right? And to what bank is it that you would be sending things?
The Zelle, I would have to look that up honestly, because I have previous bank information, and when you just hit Zelle, it just goes to the directive. So it's worked always in the past, but I have to look that up to see which bank it's actually going to. It's just listed currently under her name.
Okay, and I'm not asking my question well, but it sounds like what you shared with the county to ensure that money is transferred to Ms. Chance is the bank account information you had that allows you to Zelle money to Ms. Chance.
That's correct.
Okay, so whatever bank account of hers into which your Zelle transfer goes is the same account that the county transfer would go.
It is.
Okay.
And I will find that exact information.
I don't need it. As long as you believe that that pipe is being constructed. And that's why I was asking Ms. Chance. I want to make sure that the receiving end of the pipe is her account and not Fred Jones's account, because you didn't know and you just typed in an account number. Okay. We'll see how that plays out.
I just send him an account number because there's no way he's just going to give them the Zelle information and it's going to come. So I will send.
That would be great. And then he can confirm with the county that that's the account number. And to be very clear, and we'll make sure this is in whatever final order comes out, until the automatic transfer is in place, Mr. Weems has the obligation on the 3rd of each month to confirm, was a transfer made? No, it wasn't. Then he needs to Zelle. We know the Zelle works. And he'll keep doing that unless and until the county automatic transfer is in place. But if you would send him the account information of your choosing, then he can use that to make sure that's where the county's going to send it. So that's child support. Is there more you want to discuss about child support?
Child support, the documents. I haven't received the documents.
When you say the documents, I'm not.
Financial documents. He stated I think his attorney was meaning that they were included in the email. They're not uploaded in the court system as they were supposed to be. And if you could ask him for the date and time that he sent those emails, I don't have them.
So, two different things. People aren't required to necessarily file in the court system their financial documents. They need to share them. And so if I've got them, it was because they were emailed, not because they're in a public docket where anyone could see them, especially if they have social security numbers or account numbers. That isn't always a wise choice to put that in a public facing database. So I don't expect, and I don't know that Mr. Patillo has e-filed financial records. You're entitled to records as part of discovery, but I didn't get the sense that we were today revisiting the child support amount. Did you contest the finding? I'm assuming it was Judge K who came up with the child support amount.
It was, well, yes, it was Judge K.
Okay.
And I did, and that's why he made us exchange financials again.
Okay.
And Mr. Weems has an additional job, and that additional job was not included. And even he stated he doesn't receive an income for that. So that means he's underemployed. So if he chooses to be underemployed, and the amount of hours that he works for that particular job needs to be calculated, because that means he can be working another job and give more benefit to the child.
Okay. So, Mr. Patillo, tell me, trying to find.
You should see the W-2 from both 2024 and 25, as well as the financial affidavit.
Yep, hold on one second.
Can you forward me that document? I don't know.
Just hold on a sec. Okay.
I'll just create a separate email with just those documents on it, and I'll send that right now.
But I took me a minute to get into the information here. Your documents have interesting labels. They say things like baby shower gifts and Happy Mother's Day. What would I look at that would be financial records?
It actually should say financial records on it, but let me just make sure that's the title of it. It should say DR Financial Affidavit, Fulton. Yeah, just recent, just those three documents separately.
Okay, resent to Ms. Niles and to Ms. Chance? Okay, yeah, because there's nothing in the folder into which Ms. Niles put the exhibits you had sent. It looks like it's a lot of emails. I'm just going based on the labels you put on there, but not what you just mentioned. So Ms. Niles will forward that to me once she gets it. All right, so you're helping me understand, Ms. Chance, that one of the things we need to work through this afternoon is what is a more complete financial picture for both of you, and see where that gets us. Anything else in connection with child support?
No, that's the only thing in connection with child support.
You need to speak louder.
No, that's the only thing in connection with child support.
Okay. What other topics did you want to cover today? I know insurance. Let's talk about insurance. It looked like as I was going through some things that are actually in the docket, so public things, I saw an insurance card, the Anthem Blue Cross Blue Shield standard issue county insurance card for your daughter. Is that something you have now?
I do have it now.
Okay. I know you didn't have it before, and that was,
The physical card is what I'm waiting for, because most of the providers need the physical card for the first appointment. And I made that clear two months ago.
okay.
So he sent me an email yesterday and told me that he called yesterday for the card. And
Gosh, what I saw looked like a photocopy of it. Maybe it's a digital version of the card.
it is. So he waited until yesterday to send for the card, which is what he emailed me. And then I called myself to see was a card ever mailed out or anything. There was a card mailed out. Mr. Weems needs to perfect his address. The address that he's given me in the court is not the address that they have on file. And 2 months ago, when he had the card mailed, it went to his Sandy Springs address. So in addition, if Mr. Weems is gonna be, can we have him just perfect the address that he's using?
Okay. You don't have a physical insurance card yet.
And I have a contempt for the insurance card there too.
I know. So you're saying that the medical providers that your daughter is seeing won't rely on the insurance policy because they don't have the physical card?
Some will and some won't. So, and we're waiting to see respiratory because who we got referred to with respiratory, they're a smaller office and they want the card, but they're considered top notch for what they feel like she has.
Okay. So, Mr. Patillo, the email I've got, it's got all the exhibits that are in the directory, and there's nothing that starts with DR. I'm assuming it's like an email. One of them says, I'm at her cardiology appointment. They would like her insurance card. I'm assuming that's a PDF of an email.
Yes.
Yeah, so if you're in Zoom, you can share
No problem at all.
exhibits. Ms. Chance, while Mr. Patillo is doing that, you're entitled to the insurance card, so we'll figure out how that gets to you. Other insurance matters you want me to address?
So we have some outstanding insurance, outstanding medical bills.
I gotta pause you 1 second. The email just came through, Mr. Patillo. So there's DR financial affidavit and then a couple W-2s.
Yes, Your Honor.
And Ms. Chance should have those as well now. Okay, I interrupted you, Ms. Chance, I'm sorry.
Fine. Mr. Weems was presented the medical bill and it says, one of them is abnormally large. It's 38,000
There's a medical bill for
for
38,000.
delivery bill.
Okay,
And it was more than that. I applied for like financial assistance. The VA covered her for 7 days. That's my insurance, and then it dropped. And so we have this bill here for 38,000.
were there other medical bills or that's the big one?
That's the big one. There were a few other ones that were given to Mr. Weems.
And have they been addressed? Do you want them addressed
I want
or?
them addressed. They haven't been addressed, but I want them addressed.
Okay, and with the work you and Mr. Weems did with Judge K, did he come up with a ratio for paying?
65, 35,
You're 35?
I'm 35.
Okay. And Mr. Weems, your contention is that Mr. Weems hasn't covered his 65% of any of the unpaid medical bills?
No, but I feel like if he if he even gives them the insurance card, it may go down because this is something that wasn't added on insurance, but he's addressing nothing and it's just leaving a high bill.
Okay. Right. I mean, you should be neutral as to whether Mr. Weems pays 65% of the bill or through the Anthem card causes that bill to go down to a copay of,
Yeah, that's what I'm
right,
saying.
one way or the other, it needs to be addressed.
I mean, I feel like that's a lot of money. If she's got the benefit, give them the card or address it that way and then see what it goes down to. That's fair.
Okay. All right. And do you have all of the unpaid medical bills?
I have some of. Tried to give the insurance number to the one that would take them this week. And then, so they're not going to be the same for the ones that I don't have. So it wouldn't be fair to ask for them.
Got it. There's some that may get paid through the insurance.
Went to collections and collections, they said that they can still bill. So we'll see.
Okay. All right. So we've got to figure out child support, sort out the insurance card. There's some unpaid medical bills. Any other topics?
Daycare.
Daycare. How is that different from child support?
Because it wasn't included in, it was just going off of his income. Daycare wasn't included like a percentage. I thought daycare was, we split 50-50 with daycare.
Do you work?
I'm disabled, but I have therapies that someone needs to watch her for while he's working.
Say that again.
I'm military disabled, but I go to therapy like 3 to 4 days a week.
Okay.
And he's.
So the daycare is when you're in therapy.
It is.
Okay. How much therapy a week? Is it hours?
So I probably do 9 hours a week, but with the traffic, sometimes it's an hour and a half. Most of the time it's in Decatur. I'm in Kennesaw. So I have a in-house nanny. I have an au pair. So, and it's $350 a week. So she's $250. I mean, she's $200 straight out, but then I have to cover her room and board additionally.
All right. And anything beyond daycare?
There's an order in that he needs to return the child's, her gifts from her baby shower. He hasn't returned the gifts.
This is something that Judge K ordered.
It was. I believe that was the February 12th order.
There's not a February 12th order. There are some orders around then, but they have things like,
I think it came in later than that, like a week later when they finally put it out there. So it might be like the 20th. Is the actual date it was e-filed.
okay. Mr. Patillo, are you familiar with an order about the baby? I know the baby shower gifts are an issue. I've seen that percolate up, but is that something that's already been resolved or something that we need to address?
No, Your Honor. We've been looking for this elusive baby shower order for 2 separate mediation sessions, and we've seen nothing of the sort. The baby shower gifts are for the child, and when the child is with Mr. Weems, she used it to baby shower gifts that were given to the child.
Mr. Weems has never asked for the child.
So we're not doing back and forth yet. I asked Mr. Patillo a question. If you can find the order, you may have copies of things. Ms. Chance, I'm happy to enforce it, but I haven't seen that. There are lots of orders. A number of them are purely procedural. Video conference hearings are okay, things like that.
The first initial temporary order,
What's the date?
and it's February 12th. And it didn't get filed though, so it would be underneath the February 12th. I had to call and ask, can they upload the order because it didn't come on time like it usually does. It was at least a week out. It was uploaded.
Okay. If it's not in the docket,
In the docket, I'm grabbing it for you now.
okay.
You want to come back to it, but you want me to email it or?
Well, you just need to tell me the date because then I can find it. These are all in order. Okay. Judge K has a way of tucking into procedural orders substantive rulings. And on February 20th, he entered, and it was from the date of the 12th, so exactly right, but it was entered on the 20th. It's entitled, and so I can see why Mr. Patillo would blow right past it, because I did too. Order to attend 60-day status conference. But it's also and temporary order. And down below, and it's highlighted in yellow, respondent, that would be Mr. Weems, shall immediately add the minor child to his health insurance. We're working through that. And release the baby shower gifts to petitioner. Uses the verb release rather than return, but the direction is clear. I'll make sure I put that in the final order as well. All right, so child support amount, insurance card, unpaid medical bills, daycare obligation, and baby shower gifts. Anything else?
I had some subpoenas served to them regarding information that they needed to come up with their original contract,
Contract for what?
their client-attorney relationship, the date that their contract came about, and the first payment that was made to them, because they play a lot of games. Like, they showed up with nothing, have done nothing. They didn't show up to court on the first day. He emails the court and tells the court that his client just retained him that morning.
Well, I think that Judge K has, that's not addressing your subpoena point, but what you're describing as games or things that frustrated you, Judge K resolved those with his order that struck the answer and the counterclaims. So I think he's managed that. We're not going to revisit that.
But there were things that came after that. Still not, there was an order to come with the financials. You got me showing up to mediation with nothing.
Okay.
With my money. So there were things that came after that. He was very specific to his attorney. The attorney is withholding them. The attorney had the financial documents and said he didn't send them over because he couldn't find them.
Okay. Got it. Let's talk about financial records. So, Mr. Patillo, the direction from Judge K was pretty clear that at the final hearing, you would need to have tax returns from 22 through 25 for himself, and then any business in which he owns at least a 10% interest, he meaning Mr. Weems, any 1099s, W-2s, K-1s, and then pay stubs from all sources. I'm reading this directly from the order that was entered 9 days ago. So I find that where?
We've turned over the documents which Mr. Weems was able to recover from his employer. Of course, getting every pay stub for.
Well, it wasn't every pay stub. It was recent pay stubs from all sources. And I think that was getting at the notion that Ms. Chance has advanced that maybe there's a second job. I understand Ms. Chance's desire to paint a complete financial picture of Mr. Weems and not leave something out. If there is a second job, that's why Judge Kay said from all sources. If he's got his last couple pay stubs from the county, that covers it for the county. I don't think there's a big dispute about the county employment. It sounds like is there additional employment? Is the email that you sent, it just says pretrial directives is the name of your email, and it's got the 3 attachments, DR financial affidavit, and then W-2 for 2 years, 24 and 25. Are those the way Mr. Weems is complying with Judge Kay's directive to provide federal and state tax returns from 22 through 25, or are they somewhere else?
Those are his attempt to comply with Judge Kay's order. He's attempting to pull all his financial records through. There are a couple of issues that we've run into. Part of it is the voluminous nature of the motions that come in literally on a seemingly daily basis that we have to respond to. We believe that the plaintiff was attempting to essentially run up attorney's fees and run up the clock out in order to clog up the wheels of litigation. Secondarily, perhaps more importantly, the plaintiff has a history in this case of doxing the respondent. He's of course had law enforcement officer here in Fulton County. She's released his home address and phone number on social media because she was upset at him. She's posted pictures of his medicine and medication violating his privacy rights on family group chats in an effort to try to embarrass him. She's had him served with paperwork and information at his job, trying to essentially discredit him in front of his coworkers and potentially get him fired. So yes, Mr. Weems is very concerned about the information he turns over, in addition to having to change his phone number because of the constant harassment which is taking place on the part of the plaintiffs. So we are attempting to comply, but Mr. Weems is of course very concerned by the previous actions that have taken place, we wanted to have the court be aware of this, and then we'll be more than happy to turn over whatever information the court has. But so we have a record so that if he turns this information over and his ID and then it gets stolen a week later, we'll know exactly where these things have gone. Secondarily, on the issue of the insurance, because that's come to be a issue in this case.
And when you say the issue, you're talking about the insurance card or Mr. Weems's obligation to provide insurance, or what?
The insurance card, Mr. Weems has, as you've seen, sent pictures of the card. He mailed a physical copy of the card. He has the receipts, which are in the emails of when he mailed them directly. It seems that whichever way we give her the card is the wrong way to give her the card. And so
is there an actual physical card when you say he's mailing it and whatnot?
Yes, sir. So I actually, when they sent it to me and I provided this in Judge Kay's presence, it was sent back on April 30th, 2026. She has this. She says she didn't get it. And as Mr.
I have it.
Stop. You keep going.
Pillow stated, I have a copy of the certified mail I sent.
Okay, but so we're clear, what you held up was a piece of paper from Anthem. As an Anthem insurance recipient, I get something like that, and then rubber cemented to it, stuck to it, is the little plastic card.
So, yes, sir. So they emailed this to me. That's
okay.
The only thing I had. So I mailed a certified copy too. I presented this in front of Judge Kay as well. So there again, I am held up by an address to Fulton County. Anthem would not send me, as Chance alluded to, they sent it to a former address. Anthem would not send me a card until Fulton County verified that my address, I couldn't change my address through Anthem, even though I've been a member forever. And they wanted me to contact Fulton County. I have documented emails to multiple people at Fulton County. They finally updated my address. And I copied your office, I copied Ms. Chance, and I said, they finally sent an electric card. Here's electric card, and they have updated my address. And when they get the physical card, I will provide that as well. It's been at least a few months, and they, just in my opinion, dropped the ball, Fulton County. I have multiple emails confirming my request for them to change my address. So Anthem would, in fact, now
Well,
send a
in
card.
Anthem's defense, I see at least 3 different addresses for you across the records you've submitted. In 24, there's a Sandy Springs address that is totally different from your 25 address, also in Sandy Springs, but completely different. And most recently, I see an Atlanta address. So Anthem's probably doing its best to keep up with you, but you keep moving around.
Well, sir, it's only one address they were concerned about, and that was the 8060. I lived in Sandy Springs since I moved here in 21, and I recently or thereafter moved to the other address in Atlanta. Anthem only has the one address. The medical office or the people who deal with benefits for Fulton County employees, it was only that one address, the 8060. So it's not multiple addresses out there. It's only that one address that they would not update until recent.
Okay.
And I sent the electric card, and it's a digital card that you can pull up on your phone when you're at the medical office.
Right.
While we're on the address, can you have Mr. Weems perfect his address so that when he has the child? Because the address that he's given me and the address that even Anthem in Fulton County has, I just want to know where my child is when he has it. And that's fair.
Okay, and that'll be in whatever documents we make as the final documents. So is the Garson Drive, that's where you are now?
And it's been put on record in Judge K.
He said the apartment was 1020. When I tried to verify it to get the information.
It's a different apartment. It's a different part. We'll get that to you. But I'm just trying to keep track because like I said, I have 3 addresses across 3 different documents here. But as of today, it's the Garson Drive.
Sir, that's been put on record in Judge K's courtroom.
Okay, and it's still correct today?
Yes, sir.
Okay, all right. It's 1210.
But he gave us 1020.
Well, I don't know what he gave you. I'm just telling you what's right here.
I'd like to see that.
Okay.
I'm reporting from.
All right, we're not doing the back and forth. Other topics?
The child support, can we have an order that he signs the birth certificate? Since we're doing the,
What is the birth certificate right now? It's just one parent?
it's just one parent, and he needs to sign it, and essentially they might even kick back her insurance. Sometimes they want to know relationship as to keep the child owners. So it could be an issue later. Sometimes they give you like 90 days or something like that.
How, if you're using the Anthem insurance card with her name on it, why do they need a birth
As far
certificate?
as like with your employer, usually you have to provide something of relationship to prove when you first add someone on there. He doesn't have the social security card. He doesn't have he hasn't signed the birth certificate, so he has no way to prove the relationship. So sometimes they kick it back when you don't. That's like.
Okay, but that seems like a Mr. Weems problem and not a you problem.
It would be me if my child doesn't have the medical. She's a preemie with medical issues.
Okay, but we now have insurance. Anthem is covering. So any issue with signing the birth certificate?
Well, no, Your Honor. The reason the birth certificate wasn't signed was Ms. Chance did not inform Mr. Weems the child was born for several weeks after the child was born. That's the reason he wasn't present when the child was born, because he was not informed that the child had been born. Indeed, the child has a completely different name. Ms. Weems unilaterally decided to change the child's names to Natalie Chance Junior, similar to what Krishan Rock did with Blueface. out of apparently spite at Mr. Weems. This is a course of action which led us to request custody in this case, and that's why we believe that it will be very difficult to resolve the issues in this case, including child support, or without addressing the issue of both custody and visitation, because Mr. Weems has had visitation or has taken the child many times, but there is no clear visitation order. And when we're calculating the amount of child support, of course, parenting time has to go into that calculation. So this is why we were seeking a more complete order in this case.
Okay. And for reasons under your control, Judge Kay said that's not how we're going to work it out this time. So I hear you, and that's the ideal. It's more efficient to do it all in one pass through, but that's not how we're working through it today. Okay. I would like to flesh out that financial picture because it's all going to flow from that. That will go into the child support calculation. And so I guess it would help me to find, since you seem to have mastered the docket, Ms. Chance, is there something that Judge Kay used to develop the 973 figure?
So he did, he filled.
He did a worksheet?
He did.
Okay.
And I think that was June 3rd.
So there is a child support worksheet that was filed on the 17th that yields the 973. That's what Judge Kay did. That was tell me how you were connected to what happened. Was there a hearing in front of Judge Kay, Mr. Weems?
Yes, sir.
Okay. And did you provide financial information to him, or did you testify? How did your numbers get into the worksheet?
I presented the federal tax return or the tax,
Your W-2?
to the judge.
Okay. And then Ms. Chance, you have some figures in there as well. You presented your sources of income.
So I want to make a correction. If you read that temporary order, Mr. Weems did not provide his W-2. It says he read from the document. Him and his attorneys act like they both couldn't find him. I presented, which is in the financial documents that I presented to the court, my VA disability.
Okay. But Judge Kay benefited from both the presentation from you and from Mr. Weems. So sometimes we have to do an imputed number because there's just an affidavit, and it's basically, if it shows you are spending, I'm making a number up, $3,000 a month, then presumably you're making $3,000 a month because you can't spend money you don't have. But we now have W-2s, so we've got that. Is the W-2 information, if you know, Mr. Patillo, that you have now provided, so we have hard copies of the W-2, is that the same figure that would have been incorporated into the worksheet that Judge Kay did?
Yes, Your Honor. Numbers
And
match.
I still don't have that document. They stated they emailed.
Okay, it made it through. I don't know if it's hit a screen on yours.
That I'm included on there?
Yes, well, I'll tell you, I don't know for sure. There's an email address that ends in 05.
It is.
Okay, so that was sent at 1:30 today. It may have been sent earlier. I'm not saying it wasn't, but the one that got forwarded to me by Ms. Niles, Mr. Patillo resent at 1:30, and you were listed as copied on there with your address that ends in 05.
Can we make sure the whole entire email is correct? Because I've been having some issues with
Sure, it's your last name and then your first name and then 05.
05. Is it O or 0?
It looks like a 0 to me.
Thank you. Nothing.
Okay, well, I'll make sure you get those documents before you remind me, but I'll make sure that you get them. I don't want to put them up on the screen if we don't need to. I just want to do one quick math thing and then we'll go from there. Okay. That matches up.
Yes, Your Honor. And we ask that any requirement for documentation be reciprocal on both parties. Mr. Weems has reason to believe that Ms. Chance has additional sources of income, so would also ask that any order include her check stubs, her bank statements, et cetera, so we have a full financial picture for both parties.
Okay. Ms. Chance, before we leave the topic, I'm not going to do the child support calculation here in front of everyone. I just want to make sure I've got all the right inputs. Share with me why it is you think Mr. Weems has an additional source of income besides his county salary.
He testified to it.
Okay, in front of Judge K. Okay.
He doesn't receive income from that job. He's an officer and he works there. So he states he doesn't receive income. But even if he does, like I said, if he doesn't receive income, we either need to impute the amount that the market value of the apartment is, or we need to go ahead and impute the amount of hours that he worked at the average rate that an officer makes for an EJ.
Okay, you would like that to happen, is what you're saying. Okay. Mr. Patillo, you can get me up to speed on what it is Ms. Chance is referring to. Does Mr. Weems work an extra job at the apartment complex, or what's she alluding to?
My understanding, I'll let Mr. Weems give you full pictures.
Sure, and I'm always happy to hear from him, but he has counsel, so I need to start with you.
Yeah, Mr. Weems works about usually 12 to 16 hours a day for Fulton County. And
so less than Deputy Gordon.
sounds about right. But he sometimes, I believe, volunteers on weekends as a at a museum. And I believe Ms. Chance believes that he should be working those hours as well, and that she should be being paid if he does anything else besides work. But I'll let you complete the picture.
Yeah, sir. In our last couple of hearings, Ms. Chance alluded to, I had a job.
So let's keep Ms. Chance out of it. You just tell me what it is you do, and then if Ms. Chance has some questions about that, I'm happy to hear from her. But you are Mr. Weems. Your lawyer just said, I think he volunteers at a museum. If you've got an extra job, tell me what it is. If you don't have one but you volunteer, tell me that.
Well, sir, she said something earlier. You said you would let us respond once they were finished.
Got it. And you can respond, but just respond to me as opposed to Ms. Chance says or this. Just talk to me.
I do not have a job at a museum, is what was said. I do.
Well, your lawyer said it too, but okay.
I'm a member of that museum.
Okay.
So I attend events at that museum.
What museum is this?
It's the Hyde Museum.
Okay.
And how Ms. Chance, how someone else would know that, I don't know. Am I being tail-tracked? What? I don't know.
Okay.
But I attend there at least twice a month. And I
As a guest.
No, I pay to go there.
Well, right, but you pay. You're not there wearing your uniform.
Not at all.
Okay.
And that's been alluded to. Well, it's been, I want to just say that it's not the case at all.
Okay. Do you have an extra job?
I do not. And as far as any discounts I get for resident, it's been included in my financial statement. The amount of everything has already been submitted to the courts.
So I'm curious why you don't have an extra job. Most deputies that I've gotten to know, just because you guys don't get paid enough for the type of work you do, there's a Sunday morning at the church, you work the parking, not you personally, work the parking lot, or you might do a concert on a weekend or something, but it's not zero. And this is purely my experience chatting with deputies, but you're unique. You're going to. I'm done.
May I? Okay. You could check with the county. My division I work in, transfer. We have the most overtime in the entire office of the sheriff's office. There is nobody else who gets more time than us. You check with anybody.
And your overtime would be reflected in your W-2.
That's all overtime. My base is, my base pay is much more or is lower than.
Got it. So you don't really have time or even the financial incentive to do an EJ because you can always bank overtime hours driving to Oconee County or down to Jackson or whatever.
That's those places I drive to. So
Okay.
I drive to the Florida line. I drive to Tennessee. I drive to North Carolina. So yes, that is correct. If I'm off, I'm asleep or washing clothes. But I have told my supervisors that, I put in for official transfer out of that division because you just don't have a quality of life. And if I'm able to get custody of my child, I've already set in a meeting with our chief of that division a couple of weeks ago, and he asked to speak with him. So I've already relayed that message.
Okay. But for now, the reason why you don't show or you're not producing any extra job income information is you don't have one. Your role with the sheriff's office, as I understand it, really doesn't allow for it. Not that it's forbidden, but just one, you don't need it, you get the overtime. But because you're doing overtime, that's when Deputy X might be helping out at the Braves game or I'm making it up, whatever you're doing.
Absolutely, sir.
Okay.
I've worked 18-hour shifts, sir. And we get stuck at Grady if the inmate is sick or whatever. And and we get asked to do extra work at the jail on 1 to 2 weekends a month.
Okay.
And that's a paid position. I don't have time for EJ. There is no time. I'm not getting 30 hours.
Ms. Chance, do you have evidence you want to share with me that led you to believe that Mr. Weems had an extra job?
He swore it out in court, but can you ask him about about how he is connected to the apartment complex that he lives? Because he is the officer at that apartment complex. That is how he used it to have our baby shower. Our baby shower's address was there. And
The Garson address?
Garson address, and he used it, and he got extra time there because he's an officer there. So I want him to be very clear that if he stopped working there or stopped performing duties for them, when did he stop?
Okay.
Because I'm gonna subpoena them.
Okay. There's not going to be a lot of subpoenaing after a final order, but we'll work through that as well. Mr. Weems, you alluded to somehow you've accounted for the discount you get at your apartment complex. Just sort of lay that out. I'm not interested so much in the dollar amount, but you pay a slightly lower rent because you're effectively a courtesy officer?
That's correct, sir. And that is documented in my financial stuff that I submitted to the court.
When you say your stub, meaning the financial affidavit?
Yeah, we'll have to get that, but that's already been submitted, sir.
The financial affidavit.
The financial affidavit, and it names the discount that they give me. They have a security patrol there. They actually pay a third-party security agency. So I don't do that. They give me a discount, and I help, give advice and look out for stuff. And so they give me a discount. They already have a security agency that works at that place. So I don't.
But he has to do a certain amount of hours in order to maintain that discount. So that
That
is
is not true.
employment.
So stop. Again, we're not doing the back and forth. Your financial affidavit says your rent is $1,080 a month. There's no asterisk next to it saying it should be $1,400. But so tell me what would I pay for rent for your apartment?
They give me, and I have that also listed, they give me a $900 discount if you're on.
Okay, you say you have it listed. Mr. Patillo, you can help me out. I'm not.
We're pulling it right now, Your Honor.
Pardon me?
Oh, so we're looking right now. at the
Okay.
Financial affidavit, and I can tell you shortly. Can you just tell me where it's at on here?
This is the screen.
No, it's not. Yep, it's in this.
Oh, I think what you've done is listed it as income from royalties, trusts, or there's a 900 entry, and there may not have been, maybe it would be a fringe benefit. It probably should have been one line above, but I see it. You've included it there. Okay, you just put it in a slightly different place, but that's what that 900
Yes,
is,
sir.
is the discount you get for being a courteous officer, doing whatever it is you do, whether it's you walk around looking big with a badge on, or you do some patrolling, or you run a number, or whatever. Okay. All right. That is helpful. Mr. Patillo, what is your response, your client's response with the medical bills, the unpaid medical bills?
Well, and this falls into kind of the initial point that we were discussing. Because Mr. Weems is not present during the birth of the child, was not informed of the birth of the child, he's had absolutely zero input on any medical decisions. He has literally no rights because the respondent has refused to legitimate the child up until today. Therefore, he has very serious questions about the medical bills, to make these choices with regards to medical care, and also the choice to have an au pair that you're paying per week. That if he's going to be liable for all of these bills, we need some say in the.
Okay, well, I don't want to stray into daycare. We'll get there. But medical bills would be the 38,000 for the childbirth. Are those bills you've seen? Because you're describing medical procedures that Ms. Chance decided to do that. I don't know that the bills necessarily reflect that, as opposed to, even though it was a premature birth, it was a standard medical procedure, which costs a whole lot of money. And it may be that the 38,000 is simply the cost of a childbirth at, what hospital was it?
Northside.
Northside. That there was nothing extraordinary about it. That's the standard bill. I hear your point that Mr. Weems wasn't there, but there might not be anything in that bill that anyone could ever object to, assuming you'd want there to be pain medication and a doctor and a OBGYN, et cetera. It could just be a perfectly standard bill. Have you seen the bills before?
Well, we've not seen the bills. We've not seen the names of the doctors. We've not seen medical records as to what has been done. And further, this is going to be ongoing treatment. It's going to be an ongoing issue. And Mr. Weems, if he's going to be responsible for 65% of the bills, he needs to have a say in exactly how those bills will be allocated.
Okay. Ms. Chance, have you provided medical bills before beyond a basic bottom line? Hey, it was 38,000 for the childbirth.
I sent him the login twice to log into the account. He got the login. I guess he couldn't get
He meaning Mr. Weems or Attorney Patillo?
both of them.
Okay.
Because I always email them together. So they both got that. And Mr. Weems did have them because somehow he ended up at the Children's Hospital trying to get his name on the account. So he very much had them. He knew
Okay.
where to go.
You sent Mr. Patillo and Mr. Weems a way to log in so they could see the level of detail that you can see. Okay.
And I printed it out here, the highest bill, the 38,000, I printed it out here. And it was 212,000. My insurance took care of most of it already.
That's a big number.
We were separated at birth. She went to a different hospital, so.
Okay. It was that, her situation was that urgent that she went, or maybe yours was that urgent that you went to different hospitals.
It was hers. She
Okay.
was resuscitated, so it was hers.
Okay. How is she doing now?
Much better.
How old is she now?
6 months.
6 months. Okay. And is looking like a 6-month-old and
We have GI issues and we have to get to respiratory. She has some fast breathing.
but in terms of weight and whatnot,
Not weight wise, we're only 11 pounds, but we're getting there. You wouldn't know.
Okay.
Wouldn't know.
well, congratulations to both of you that she's doing okay. Mr. Patillo, Ms. Chance says, I gave you guys the login information so you can satisfy your deepest question about what the medical records look like.
10 minutes ago, we said we gave her login information for the cards. That was insufficient for her.
I'm just asking you, did you get it? I don't know if you got it.
Change the password.
Yeah, we were not able to log in. That's
So
why
there's
we're
no
asking.
Stop. Okay. All right.
This is why we're just simply asking for physical copies of all medical bills and all medical records. Because Mr. Weems also, if there's, maybe he has a doctor he wants the child to go to,
Mhm.
maybe there's procedures, et cetera. He needs to know the child's medical history, medical records. He's not an ATM, he's the father.
Okay. He may be both, but yes.
But I do want to say, that Mr. Weems is not legitimate. He's chosen not to participate after being offered several times to participate. I went to the hospital because I had a seizure over my blood pressure being high. Mr. Weems was told to pick up the child. Mr. Weems didn't show for 38 hours. When we reached out to him, he was like, oh, he's at work, he got to get off. And that was
Okay.
the day before. So Mr. Weems chooses not to be a parent. So I'm not going to go throwing all this stuff if he wants to be a
Okay.
parent.
And you guys don't need to argue with each other through me. I appreciate that both of you are frustrated with where this situation is, and the goal of today and what flows from it is to make it easier for you both to have a productive, healthy relationship with Natalie Junior. I'll let you know my primary focus is what's in the best interest of Natalie Junior and not Natalie Senior and not Mr. Weems. It's going to flow to you all as it ought to as parents. You're both parents of this child, and the end game is to make things as good as possible for Natalie Junior. And that's where we're focused. All right. The daycare. Mr. Patillo, I want to give you a chance to elaborate more on your concerns there. If for now, the primary custodial parent is Ms. Chance, she's empowered to figure out what ways Natalie Junior will be cared for while Natalie Senior is in therapy or working or whatever it was she'd be doing. Was there something about an au pair that was particularly problematic to you, or just you think there needs to be some collaboration as to how care is provided to Natalie Junior when a parent can't be there for her?
Well, that's part of the issue. That there's never been a situation where a parent can't be available. The custodial parent decided unilaterally that an au pair would be appropriate. Mr. Weems would like right of first refusal of any time that if you need to be in therapy, you need to be somewhere else. He's missed nearly 6 months of bonding time with his newborn child while they're with an au pair that he did not consent to, that he did not have any input in. He doesn't know who this woman is from a stranger walking down the street.
Okay.
And therefore, Mr. Weems very much would like to have right of first refusal anytime there's an opportunity to care for the child, and that therefore and even the selection of the au pair, for all we know, there's an au pair that costs 1/4 that price for the same quality.
Okay. It didn't sound like a super expensive au pair, but I hear you.
But also, Mr. Weems had wanted to make a statement on this point as well.
Well, we are now on that part of it, sir, but as far as the medical, the insurance, it was after our last, on July 10th, Friday, July 10th, when I emailed Ms. Chance to ask her to let Children's Hospital of Healthcare even talk to me. You know, I was trying to simply add the medical card. I physically went over there. I asked her to call. They said, well, we can't even talk to you. Well, we know you have a card, you know, so I wanted to apply the card to the medical bills, and I didn't have any rights as far as was mentioned. The legitimation just happened. I mean, we've been trying to get that for months now, and it's just a whole lot of. And as far as the gifts, I never did get over to this side when you left the other side, so I wanted time to say that.
We'll get to the gifts.
Okay.
Okay. All right. In fact, that's what's next on the list is the baby shower gifts.
I think Mr. Weems also made a point on the child care, the last point we were addressing.
Right.
I'm just really concerned about the child's care because I've picked the child up 3 times, Your Honor, and only one time Ms. Chance was present. There was a strange lady I didn't know there one time. There was a lady she told me was a au pair another time. There was her ex-husband giving me my child twice.
Ms. Chance's ex-husband, the au pair's ex-husband?
Miss Chance's ex-husband,
Okay.
a strange lady that I don't even know her name, and then another lady who presented herself through a Ring camera. She said she introduced us through a Ring camera.
Okay. And when you call this lady strange, just meaning you don't know this
I have
person.
no idea who she is.
Okay. So stranger as opposed to she had 3 horns and was.
Stranger.
Okay.
Stranger. So I had to be introduced through a Ring camera who the au pair was. I was not introduced. This lady that came out, I was in the driveway returning the baby. So I've had my daughter 3 times and cared for her. And the strange lady was there. I don't even know who she was. Her ex-husband, who she's not, I guess, in a relationship with, I'm not sure, but it's her ex-husband, brings me my child twice. And I'm like, why are these strange people out of 6 encounters? Miss Chance was there 1 time. And I'm like, why is this the case? So I'm definitely concerned about, my daughter's care, who she's with. I just don't have any decision-making here.
Okay. Well, I know you wanted to engage in a custody discussion and you counterclaim for that, but for reasons Judge Kaye made very clear, those claims got dismissed from this litigation. So to Mr. Patillo's point, we will likely be back together to have discussions about that. Normally we would do these together, but that's not what this got teed up to be today, through steps that you took or chose not to take that reached a point where Judge Kaye said is enough, and he struck your answer and your counterclaim. So today we're not working through custody, but what you shared with me is not lost on me. And again, my focus is ultimately what is the best interest for Natalie Jr. And there was a guardian briefly in the case, but the guardian was released from the case because your counterclaim got dismissed. Next time, don't get your counterclaim dismissed, and the guardian will stay in the case, and we would have a neutral third party who spends time with Miss Chance, gets to meet the people in her life, spends time with you, gets to meet the people in your life, and comes and tells us all, I've met everyone. And because, of course, if I listen to just one side, the other parent is an awful, awful person. If I listen to you, Miss Chance is not even ever around her kid. If I listen to Miss Chance, Mr. Weems won't even pay the most basic of bills. And I trust you both care a whole lot about this little girl and want to be there for her. That's why a guardian can come in and hear both sides and sift through all the static and say, here's what makes the most sense.
Yes, sir.
That's just not what we're doing today because you got your case tossed.
I'm not sure that I take your word for it, but I wasn't aware of that because the guardian, I paid for the guardian, it's like $4,000 to be, she listened in on one case and withdrew. So I'm not sure that.
Well, she didn't withdraw, and you and Mr. Patillo can talk about this when we're not all together. But you should read Judge Kaye's order from June 3rd, because that's when he got rid of your case, and he explains why he did. And because he was getting rid of, and not that he said you lose, he just said, I'm dismissing it. And Mr. Patillo was correct. He said, you can bring it back, but we're going to now focus just on the paternity piece because A, B, C, D, E, he spells it out. You can read it. But because we're not talking about custody, his final sentence in his June 3rd order is the guardian ad litem is discharged. Because he struck your counterclaim for legitimation, custody, and parenting time. Those weren't an issue before him anymore. There's no need for the guardian. Whether you can get a refund or use that same guardian when we reconvene, because it's going to come to me. You're not going to get a different judge. Should you decide you want to file a custody pleading, maybe you can get Ms. Millard in the mix, and you already paid some for that, so maybe she would continue to help out.
And Judge, I think a very, very important part of this is a baby shower was thrown, and you said we'd go back to that, and there was a no-show by the mother. I had out-of-town family and guests, and the gifts, these are folks from paid income, set incomes. It's not a lot of money, and most of the gifts were bought off of a catalog, which was provided. And my family bought off that catalog and went directly to her house. So you talking a few blankets, pamper boxes and stuff like that. There's no elaborate anything for the gift. Second of all, the name of the baby, I was told that first didn't have a baby shower for other two kids that were 10 and 11. So I threw a reveal party. I had one family member there that they were only able to get there. About 20 of her friends and family and guests were there. And the baby's name was announced at that reveal party as Taylor Ammerman. Where Natalie Chance Jr. came in, I agree with Mr. Petitioner. I think it's just out of spite or something like that. But that name never came out. So the baby's name was Taylor Ammerman. And it was on video chat, live chats. And it was at a restaurant where I footed the bill for 20-some people, open bar, food for everybody. I produced gifts, everything. And lastly, during the whole pregnancy until I got pushed away, I cooked meals for Miss Chance. I juiced juices for the health of the baby and her. I bought groceries for her kids, took them out of their house. We're separated. We don't have any connections. But I did that for the welfare of an unborn child. And I've done a lot to help this situation along. And I just wanted the court to know that.
Okay. I appreciate you sharing that. How did the two of you first meet?
She was a nurse in a place of employment.
NAFCare?
Mhm.
You were a NAFCare nurse out at Rice Street. Small world. Okay. All right. Mr. Weems, I appreciate you sharing that. And those are the kinds of things, should you pursue the custody action, you're going to want to share with the guardian ad litem, and we'll factor all that in. Ms. Chance, is there more you want to say on any of the topics that we've been covering?
Again, he's not legitimated. I just want to know he is free to pick her up anytime he wants to. I've always left that door open, even in the co-parenting plan that I put in.
Right, there's a parenting plan in the mix. That's just your perspective on how it would work? Because it's not signed.
There were two. So I presented something and he presented something also. And I think it says like consent something. It's under, that was the platform. But it was, it was pretty fair. Like it was giving me full custody because he hasn't spent any time with her, but it was given a specific plan as to, more time, and then to generally go to split custody if we're in the same area when the child starts school. Like I haven't given him any issues on being a parent. He's free to get her, but he has to produce that address because if something happens to him and the child, I got to figure out where to start, and that's fair.
Okay, so in the docket, there's something labeled consent parenting plan signed by both parties. But if I then look at the components, one of them this is why I was confused about the insurance card. It's just a bunch of emails that include, it's what you've been talking about, Mr. Weems. This is your, so employee benefits from Fulton emailed to you, Natalie Junior's insurance card. And then your lawyer's in there. I guess this is all showing that, and then you are forwarding it to Ms. Chance Senior. But that's not a parenting plan.
No, sir.
Within one of those is a parenting plan in there, but it says signed by both parties. I reached out to counsel and said, hey, can you fix that so it doesn't slide by and get signed? And he wouldn't fix it. I never signed it nor saw that parenting plan.
Okay, there's a comprehensive parenting plan and order.
I submitted
Hold on. Go ahead.
a notarized parenting plan.
Let me see which exhibit it is.
But it's something that you signed, not Ms. Chance.
Yeah, I submitted for the court, sir.
Okay, all right. I just want, if there was something you two had already agreed on, there's no need to reinvent the wheel. But it doesn't sound like that's something that the two side, I know mediation didn't work out, but there wasn't some other set of agreements that I ought to be incorporating.
No, but I do have a question. So I get that his pleadings were struck, but at the end of the day, the child being legitimated is the best thing for the child. So is that not something we can do and leave with a plan today? Because it's my child. It's not about win, lose. It's that if something happened to me today, like we would have to go through a whole long process to.
Right. Well, we're going to touch on that because Mr. Patillo said we've solved the paternity thing. And so I want to know what in here, and again, Judge K may have tucked it into one of his orders.
I provided a paternity order on the 12th when Mr. Weems didn't come to court that day. I
Okay.
came with the paternity order, with the DNA order, sorry.
But the other thing I'm hearing you say, Ms. Chance, is that you are not opposed to having in the order that I entered that is more about child support and medical bills, et cetera, something about visitation, so that there is a structure in place. Okay. All right. Mr. Patillo, two things, and then anything else you all want to cover. What were you referring to? This is number one, when you said, but after date X or after hearing Y, the paternity situation was resolved or agreed to or settled. What do you mean by that?
Well, after he took the DNA test in February, the results were sent to Judge K's office and to the petitioner in this case. So as far as we're concerned, he has taken on responsibility for the child. We're just waiting for the documentation for him to sign for legitimation.
Okay. I've never heard Mr. Weems say anything other than I'm here to take responsibility. So I want to be clear about that. When you say documents for legitimation, where would those come from in your mind?
Well, just any order from the court. Just
Okay.
That such when he went to try to add the child at the hospital, he needs something.
From a court. So they would say, who are you? The fact that you're carrying around an insurance card for this little girl is creepy because you've got no connection to her. Okay. In what way did you get something to Judge K? You said we got
and I'll share the email. It's an image file. Well, let me make sure.
Did he turn that email then into, all right, I now in one of my orders am saying this?
No, he didn't.
No, he did not.
I've never seen the DNA order there. I added the DNA order to Zoom, but I don't think it was ever uploaded or he took it from there. So with me adding that, that's how he made the order to add the child on insurance. But I can assure you there's no DNA.
There's no order that, okay.
So these were the test results that were turned over.
Are you putting them on a screen? Oh, here they are. Look at you. Good job.
I paid for that
Okay.
prior to any order. So I want to know.
And I think there's one more document. Might be the 23.
So maybe there's something more compelling. Oops, it just went away.
I'm showing the second one. Yeah, this the test results showing there's a 99.999% probability.
That's okay. Got it. Because the text is he's not excluded as the father, but that is less compelling than that number that's effectively 100%. Okay. Got it. And this is something you've seen before, Ms. Chance? You have. Okay. And apparently Judge K saw it. It just wasn't then converted into a ruling on his part. And so you continue to labor under the disability of not having proof of you have that, but not legal proof of paternity.
Yes.
Okay. All right. Do you, Mr. Patillo, have any objection to the final order that flows out of today's proceedings including a temporary set of rulings on custody and visitation. I emphasize temporary. Some of my rulings will be final because we're here on a final hearing in connection with what Ms. Chance has been advancing in her pleadings. You sought to move forward with custody and whatnot. That Judge Kay said that's not going to happen right now. But I think everyone agrees getting a structure in place, a temporary one that can be amended as you pursue what you want to pursue, would be particularly healthy for the child, but it would provide a framework for the two parents as well that ought to lower, I think, the temperature in the room.
I'm just thinking, we're having a temporary work before we come back.
Yes.
Yes, Your Honor.
Okay.
I have a question.
Did he have a question?
Yes, Your Honor.
I'm ready.
It was presented to the court that I missed the court date. I've taken off several days of work, maybe, I don't know, half a dozen or more. I just want to speak for myself. I've not missed any day of court that I'm aware of at all. Matter of fact, we had to postpone one of the mediations because the other side didn't pay their fee for the mediation. I was taken out to Cobb County Court during this, in the last, during this session of these hearings and tried to be made the same charge that Fulton County is already dealing with.
I'm not following that last point. You're saying there was a suit filed in Cobb County?
Yes.
Oh, okay.
I'm putting it on the screen, sorry.
And they actually said, no, it's already being dealt with in Fulton County. And that day, I waited almost an hour and a half. The other side was late to court, didn't show up on time. And it's like, why am I being dragged out to Cobb County for something that's happening already being dealt with in Fulton County? So they dismissed it after I presented that it's already being dealt with in Fulton County.
All right.
Do we have an abandonment case open in Fulton County? Because I have done nothing. He keeps swearing that out. I have done nothing in Fulton County about abandonment, and that is what he's speaking of.
No, he's saying that there was something in Cobb County, and you can see on the screen here, that's Magistrate Court of Cobb County. And there's a notice that a complaint has been filed against Dwayne Weems Junior about abandonment of minor child. It's got a case number. That's not here.
He's saying that it is being the abandonment is being taken care of in Fulton County. That is what he's saying. And that is what he told the judge there. And I've done no such thing in Fulton County. Fulton County sent me to Cobb County where she was a resident.
Okay.
So can you just assure him that there is nothing here and nothing open, because he's saying that it's being taken care of here?
What I heard something different from Mr. Weems. It was that when Cobb County learned about the paternity action that you brought here in Fulton, that Cobb said that will address the issues that were being brought in Cobb. And so this is the case that would move forward, the Fulton case and not the Cobb one. Not that they're identical. Abandonment and paternity are different, but they're connected. And certainly if the way this paternity case played out, it's not, but if it turned out you are not the father, then how could he be liable for abandonment? He couldn't.
It was already discovered at that time. I went in there with the DNA test. He swore out that it was being taken care of here, abandonment.
Okay.
And
Well,
I just want to assure him that there is no abandonment, nothing open here, nothing that I've done.
got it. He's assured. There's the only action that's pending in Fulton County is this one. All right. Anything else?
And Your Honor, if you have an opportunity to look at the screen, this is part of what we're talking about when it comes to trying to get a resolution to this. The child abandonment warrant wasn't taken out because Mr. Weems abandoned his child. She was simply upset about something, and also in this email says, I'm going to include your chain of command, because she wanted to discredit Mr. Weems through its employment. We just need any final order to stop these things from taking place.
Okay, I'll have a no disparagement clause in there that will flow in both directions, but that needs to be a way we work through this. In fact, I want to float this idea between the two of you. It's not uncommon in a final order to direct the parties to communicate through a particular medium that we have for parents that are working through custody and child support and whatnot. So you don't call and you don't email, so there'd be nothing from any of these email addresses. It's like texting, but it's through a portal, and everything that you send is archived. So that if we ever need to reconvene, it's real easy. I just log in and I can see who said what to whom. It tends to lead to more civil discourse, but it also keeps other people out of it. Because I notice here, Ms. Chance, you said you're including chain of command in the email.
Right, he's an officer, and that is my daughter's insurance. So he has to be good and upstanding, withholding her insurance card, and he withheld it because when he had the child in his custody, I have a receipt here. He used he didn't even give me the number. He used the insurance card at the pharmacy, so he wouldn't have to pay $129. So he held the card. He used it for his benefit, but withheld it from the child. That
Okay.
is the abandonment, and that is something that chain of command can make him give up that insurance card.
Okay, so one, that doesn't mean he had the card, a physical card. He may well have had the digital version. Plenty of pharmacies accept the digital version. But two, more fundamental, going forward, you don't get to decide what the chain of command needs to know and not know. In the same way that Mr. Weems isn't going to be deciding what people who are important in your life, whether they be family members or friends, or if you are working employers. It's not appropriate for you to push to Mr. Weems's chain of command anything, period. If you want to communicate with Mr. Weems outside this portal that I'll describe in the order, it would be through his lawyer, Mr. Patillo, unless you all want to agree right now. I'm not going to impose the portal on you all.
I asked for that in my parenting plan.
Okay, good. It just, it works
I'm
better.
agreeable, sir.
Great, done. All right. That'll be in there. I think I have all the pieces then that I need. I guess I should ask, Mr. Patillo, you or your client intimated that there were potentially other streams of income for Ms. Chance. You, of course, want the child support worksheet to be balanced on both sides. And we've got the extra 900 now that I understand for Mr. Weems, and I'll get that in there. But I want you to flesh out a little bit more what your concerns are, if they're anything more than speculation. And then we've got Ms. Chance right here, and she's got paperwork. She's been pretty thorough with the paperwork. We can explore that.
Yes, Your Honor. I put in a motion to request an explanation for income from the other side, because I know for a fact they owned a car, I think Euro or some name of it is a car rental place. So she goes out and purchases automobiles and rents them out. She has several trusts. She used to own a trucking company. She has had several, to my knowledge, when I did know it. So she claims there's $6,000 a month from VA, which, going all the way back to medical, our agreement was I don't have a problem with put my daughter in medical at all, but it was her suggestion that it just needed to be covered for the first 7 days, and then the VA pick up after that because of their breakdown in newborn structure. But stay on my medical. I don't have no problem with that. But I am concerned about that part of it, just other income, and whether it's being put in trust getting paid under other names. I mean, there was bonuses from 2 different hospitals. $25,000 bonus. There was a $20,000 bonus, both Piedmont and Emory signing bonuses that were received. And I just want to.
These are all things that would have been after Ms. Chance left NAFCare?
Yes.
Okay.
Absolutely. I was there physically. I had my own apartment. She's renting a 5-bedroom house, so paying for au pair. How was all these things being met off of $6,000 a month? So I have an interest in that. To see.
Okay.
And other businesses in trust, these signing bonuses up to about $50,000 in that. And she's told me she has a bank account with over $200,000 in it. She made a lot of money during COVID as a travel nurse, and $250,000 was in some account at some point in time. And she's told me of these large amounts of money. Now, I'm just wondering how the expenses fit. And I only have one job, so I don't know if it's distraction to keep saying I work at a museum or this, that, and the other to get the focus onto me. I don't know. So I did put in a motion for that.
Okay.
And just really concerned about that.
All right. Ms. Chance, two things flow from that. One, is it your sense that the health coverage that Mr. Weems can get is better for Natalie Junior than the coverage you could get?
Mine is better, but I had some issues. I sent him a copy of her birth certificate. Her birth certificate says girl Chance since I was at one hospital and she was at the other hospital. I put in to have it amended, but with the amendment, I have to wait. They never issue her a social security number. So the VA won't add her. They did away with account numbers and everything is social security numbers. So
she still has no social
no
security
social
number?
security number.
What do we need to do to get her a social security number?
So I think I slowed it down because I turned in a copy of her birth certificate with the new name. So now they said they're issuing a birth certificate in girl Chance. And when the amendment comes, I need to bring it back. So I'm still waiting on the social, but I will add her to my insurance because it's no extra cost. I have other children that use that insurance.
Okay,
So
and you think the benefits are good benefits?
I do.
So you would move Natalie Junior to your insurance as soon as she gets a social security number?
To social
And
and Champ VA.
How quickly do you think you can make that happen?
I don't know. I'm working on it. I just went to Social Security on Wednesday of last week, so I'm working on it.
Okay. And as far as you know, the only obstacle to adding Natalie Junior to your insurance is the lack of a social security number.
Lack of a social, and they are 4 weeks backed up right now. So once I give them the social, it'll take about 4 weeks.
Okay. Your finances, did you prepare a financial affidavit that you swore out?
I worked with someone to write it out for me. But
Okay.
Mr. Weems is swearing all these businesses. If you look on,
I just want to know if you have, Mr. Weems has submitted a sworn financial affidavit, which means if you someday learn that he omitted something or whatnot, that's perjury and this and that, all sorts of bad things could flow. I don't know that I've ever seen a financial affidavit from you.
and his attorney, let's see what it's under.
I'm not saying you didn't, I just want to get it.
I did. So
Okay.
maybe May 15th, somewhere around where that first order is for, or that first time we went to mediation.
Okay.
Hey, Judge, may I say something that I forgot to say on my list here?
Sure.
Along, and you've already covered the charge or the complaint against me in Cobb County. So there was in the genesis of this, and I tell you how I know, because my internal affairs office, they called me. I had to sit down with an interview with Sergeant Ellison because initially there was a TPO put against me. It was never signed off on. I guess whoever it was submitted to didn't sign it. My office called me. They said, hey, you know, you're being sworn off, so this could be a problem. So what's going on? So I had to communicate with them for the first couple of court sessions, let them know it was a civil matter, it's not a criminal matter. And so the other side did try to put a TPO on me, and I'm like, we're not even communicating, we're not seeing each other. Where'd this come from? So I'm just very concerned about that because my livelihood. And Judge Cade was told about this as well, and he advised Ms. Chance, if this happens, how's he gonna pay child support? He said that in open court. So I just
Okay.
wanted to make you aware of
All right.
that as well.
That's helpful context.
Your Honor, they were asked in a subpoena to produce those documents. No such things exist. Him and his attorney both said that they were in receipt of them, and I put a subpoena for them to produce those documents. What's a partial TPO or somebody almost putting a TPO? He stated he was in receipt of it, and we need to know what it is. If one person has a TPO on the other, it will affect how you give out the order for us to exchange with the child. They need to produce that.
You didn't ever try to take out a TPO?
I never did such a thing.
Okay, well, I don't want to go down that rabbit hole, but it's helpful to hear what Mr. Weems was bumping up against, and
He
I'm,
has a TPO. He said he had it in his receipt. We need to see it, and there's a subpoena for it. I subpoenaed them to produce it.
okay. How about your financial affidavit? Are you finding it?
No, I'm not.
Okay.
I'm not into that.
Concerned the financial
You looking in May?
Am I looking in May?
May, I think it was like.
Do you think it would be in the docket?
I filed it, so I thought you were supposed to file it.
Oh, if you filed it, I don't know that you were supposed to
Yeah.
file it.
I thought I was supposed to file it, so.
Maybe it's
In
part of
October?
there's another one of these consent
It's not in the consent. It came before that.
parenting plan, but this one's different. Let's see, required documents to be produced.
I think that's it.
So you did file something, Ms. Chance, that's labeled required documents to be produced. It's not quite a financial affidavit. It says these are the things that you need to give to the other side. And one example is provide your W-2 or 1099 for the past year. And you said you've provided your W-2 for tax year 2025. I assume that means you got it to Mr. Patillo.
Correct.
All right, because I don't have it, but you weren't required to send it to the court at that time. It may be that I have Ms. Niles send you the financial affidavit so you can fill that out and attest to it, because I don't see one in the record. And it's okay that it's not in the record. It's not really required to be in the record, but it needs to get to me one way or the other. So that may be something it's probably something I need to get before I can finalize what the child support calculation is going to look like. Although if Judge K was able to do the math that he did, you must have given him documents.
I did. I gave him the final document that I receive every month from the VA.
Okay.
Required that.
All right. Well, I'll probably have you do an affidavit. So you're filling out the very same thing Mr. Weems did, and it subjects you to the same liability it subjects Mr. Weems. If you are not including a trust that you are benefiting from or a bank account where you've put money, and then later on, Mr. Patillo does some subpoenas, and lo and behold, there's a Wells Fargo account that is to your benefit, and there's $50,000 in it. You didn't include that in your affidavit. You would have sworn out a document to the court that is false, and that's always a bad idea. So I'll make sure that you do that affidavit and that it gets to Mr. Patillo as well. Okay. Mr. Patillo, anything else on behalf of Mr. Weems?
Only that we do have a timetable, and we would like us to file the For a final determination on both custody and visitation. I know you're gonna put it in temporary order today, but do you have a timetable when you'll make the final?
No, you can file whenever you want. It won't slow things down here. We need to get closure on what Ms. Chance has filed, which will be closure for both sides on a number of issues. And then it will at least set that temporary in place, so that when you file the custody petition, really Judge Kay can, because he'll want to set a temporary, but there'll already be one in place. Do you need to take a break? I didn't think to ask. We're almost done. You think you can make it? Okay. So the timing is really up to you and Mr. Weems.
All right. And then also, I believe petitioner earlier stated Mr. Weems can see the child whenever he wants to. I would just want that included in for a temporary order.
Right. It's not going to say it quite like that because I think that's too free form and will create some confusion. And so I'm going to put a little bit of rigor around that. So it won't be 3 a.m. Hey, I'd like to see, not that he'd do that, but it's going to be a little more structured, and it may be too structured. We can always come back and modify temporary things. We're not going to come back and modify the final things.
And then just finally on the temporary, Mr. Williams would like it if Ms. Chance or just a single designee could be in charge of turning over the child. Not, as you said, strangers, strange people. So if there is an au pair, then that person, not a ex-boyfriend or man that he doesn't know holding his daughter, those sorts of things.
Can I help you out with that, Your Honor? So
You can't, hold on. I get it. I'll think about how we structure that, but I wouldn't want to preclude Mr. Weems from a potential visitation opportunity if at that moment the designated person wasn't available to bring Natalie Junior to him. So I'll think through that. I understand the concern, Mr. Weems, and it's very natural, but I'll need to think through a good way to structure that because neither side is able to say you can't have people in your life. And that's not what Mr. Weems is saying directly. But Ms. Chance is an independent adult, and she may choose to have someone in her life that Mr. Weems doesn't know. And when he sees that person, may say, that's a strange person, but it doesn't make that person strange, and it doesn't make that person someone who shouldn't be around Natalie Junior. In the same way that Ms. Chance doesn't have the role to say, I don't like Weems's new girlfriend. She can't be around my kid. I mean, hopefully we can avoid those kinds of struggles. But at this point, we're not there yet.
Yes, Your Honor.
Okay. Was there something you felt you needed to add?
Yes, so the au pair can't work all day. And sometimes if I have therapy and it's her time to be off, then he may receive her from somebody else. The person he received her from was my mom. He doesn't know my mom, but that's my mom. So
Is that the strange woman?
The strange woman.
Okay.
And then my older 2 children, their dad has been instrumental because I had a C-section. So he had to be there to take care of his kids, and he spent time with her too. So when he takes them, if I'm going to an appointment, he takes all the kids. But I got skin in the game because I raised his sister's kids when she passed away. So he's willing to do the same. We co-parent well. So it's just not strangers, but you may not, I plan on keeping this au pair, so it'll mainly be the au pair doing the transition.
Okay. All right. And Mr. Weems' request is a reasonable one as long as it makes sense given your life flow as well. So I hear both of you. How many people live in your household? If you were to say, Judge, come on over for dinner on Sunday night, how many people would be there besides me?
Me, my 3 children, and the au pair.
Okay, so five people, 3 of whom are your kids, 1 with Mr. Weems, 2 with the other gentleman you mentioned, then the au pair. And the au pair is roughly how old?
She is 26 and she's from South Africa.
Okay. All right. This has been helpful to me. I hope it's been helpful for both sides to be able to get some of this out that you can't necessarily get out in pleadings. I will take this under advisement. If I have questions for one side, the email from Ms. Niles will go to both sides. If the other side that wasn't asked the question feels like you need to chime in, feel free to chime in. But I'll have Ms. Niles make it real clear. This is a question for Mr. Weems. Doesn't mean you can't answer. Just means, hey, this is something that another piece of information we need. But there won't be any, if it's for Mr. Weems, we just send it there. It'll go to everyone. I think one of the first things out of the box is going to be getting an empty financial affidavit to you, Ms. Chance, so you can fill that out. And I'll move forward once you've done that. I'm also going to be looking to you, and I'm not shifting burdens here, but this is something you, I think, are uniquely positioned to do, to accelerate as best you can this birth certificate, social security number issue. And if you learn that a court order would make it go even faster, let me know that.
Can we try that? I think.
I just don't, I would need to know what the order says. So, and you don't need to tell me right now, but if you talk with Social Security or Vital Records, the people who do the birth certificates, well, if you had a court order, we could do it tomorrow. Then you just let me know what that court order needs to say, including Mr. Patillo and all of the communications you have with Ms. Niles. But if I can loosen it so we get it sooner, I think it will clear up a lot if you get Natalie Junior back under your health care.
Absolutely.
But we can't do that till we clear up that paperwork.
Okay.
All right?
And additionally, when you do the arrangements for custody and her visiting, I just want you to keep in mind, she's a breastfed child. So sometime if she goes away for the weekend, it's hard to reset and get back. She takes a bottle from dad, but doesn't take a bottle from me. So think, when you put in whatever your order is, please try to, it's hard after 2 days to get back on breast.
No, I hear you. That's an important point. And Mr. Weems, do you have other kids?
I do.
You've been through the infant process before?
Yes, sir.
Okay. Then I don't need to explain to you that visitation will be very different as time progresses. The interactions will be different. The duration can be different because you move beyond some of the constraints that might be imposed, because there's a reason why Natalie Junior needs to be near Natalie Senior from time to time, as opposed to it can be exactly equal if that's where it ends up. It just may not start that way.
Yeah, as she stated, I've completed a complete detailed list of care, bottles, ounces, diaper changes, poops, all that stuff. It's been submitted to the court. So as she mentioned, I don't have a problem. She doesn't. Well, she said I don't have a problem giving the baby a bottle. The baby doesn't have a problem, even though it's said to be breast milk. So I've tried 2 different formulas, and one she likes better than the other.
Great.
So,
And I didn't hear Ms. Chance say anything negative about your ability to care for Natalie Junior. She was simply explaining it gets a little complicated for her when the kid's away, and then the reconnection. And that's an excellent point that I need to keep in mind. Hence my explanation that you might see a visitation schedule, temporary, that seems is kind of restrictive and it's not very long, but the reasons for that are not any, I don't trust Mr. Weems with the kid so much as based on how this child gets its nutrition and the link that a mother has that a father doesn't to that, it's just going to look different than fast forward. And this is a kid who's age 2. And then that's not what the situation is.
And lastly, it was stated that I never asked for the baby. I asked for the baby, gave her 3 days, 2 or 3 days notice, and I was said it wouldn't be possible. So
Okay.
that did happen just
We're going to agree to disagree again between the two of you.
Well, it's in the text. I got text messages.
Okay. I believe you. I've got plenty to work on here. And like I said, I'll have Ms. Niles reach out to both sides if I need to get something more from either side. So, Ms. Chance, last chance, anything more we need to talk about today?
No, I think we pretty much summed it up. The only thing I do want to add is Mr. Weems is concerned about the cost of the au pair. If you look up the cost for daycare in Kennesaw, it's more than what we pay for the au pair. So I did do a cost analysis. I didn't just wing out there, but I felt like with schedules, it's easier with the au pair because we can control her schedule more than being controlled by a daycare schedule.
Okay. I was not flabbergasted by the dollar amount that you shared. And what I heard Mr. Patillo saying on behalf of his client is simply, it's frustrating for Mr. Weems because he has no input at all. And maybe purely making this up, once you said au pair, he's like, great, I got a perfect idea, and she'd work for less or something, who knows? But that dialogue didn't happen, understandably so. My goal is to work towards a setting where that dialogue would happen, about potential improvements to situations. Mr. Patillo, anything more on behalf of Mr. Weems?
Mr. Winsett.
Yes, Your Honor, just to be clear, I'm glad we got past the address part, because that was restated several times with Judge Kay and Judge Ellaby. The address is put out to the public, so the other side should have the address. Just let the court know, I do have space for an au pair at my residence. I have a totally whole room. The child has the room, its own bed. They have the other half has its own bathroom. So they have their own space that wouldn't intermingle with my space.
Okay, good to know. Appreciate it. Well, everyone, thank you for your time. I will excuse you. We will be in touch with any follow-up.
Can I just present to him these medical bills that he was concerned about? So
Yeah, why don't you give them to Mr. Patillo? That would be great.
And this is the au pair agreement. Everybody knows how it works.
All right,
That concludes our business, Your Honor. Be excused.
you may. In fact, why don't you guys go first, and Ms. Chance, you sit tight here. We'll let Mr. Patillo and Mr. Weems go.
Thank you.
You're welcome. Appreciate everyone's time.
I don't know if I can see her today.
I can deliver.
The unicorn?
Yeah, she likes it, when she comes over.
We're all done, so you don't need to take anything more down.
Yeah.
Ms. Chance, tell me how that assistance helps you.
So I have a military injury where I had a weapon go off by my ear. So sometimes if I have tinnitus, I can't just read the lips. I need some more so see what's going on. So it just depends on the.
Got it. It's another way to be following what's being said. Okay. Where did you serve?
The Army for Bragg.
So whatever happened on US soil. You weren't in Iraq or something.
It was on US soil. It was training.
Okay.